Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to the webinar where we'll discuss Pennsylvania's right to know law as it applies to law enforcement agents. A couple preliminaries that I think we should get out of the way first. This PowerPoint that we're using for the presentation this morning can be found on our web page at the training page. Go to the main page, scroll down, and all of the PowerPoints that we use for these webinars are available there. Feel free to download them for your own reference, or if you're conducting some local training, you can use that as a resource. Also, this session is being recorded, and if by chance some of your colleagues wanted to participate but their schedule wouldn't allow it, you can send us a flash drive and a self-addressed stamped return envelope, and we'll be happy to make a copy for you and mail it back. It takes about, I'm going to say turnaround's about a week. We would love to be able to post them on the website or email them to you, but the file size is so large that it doesn't make it through our security protocols with our information technology system. So send us a flash drive and we'll be happy to accommodate you. You will be able, oh, sorry about that, pardon me. You will be able to ask questions as we're proceeding through the presentation. Type them in the meeting chat feature, and I'll do my best to answer them as we're going along. Two things. First is that, we're talking about the right to know law and law enforcement, so let's stay on topic with that. And the second is that I would ask that your questions not get too complex, okay? Try to keep them short. It's just awkward for me to sit here and read through your questions and everybody else is waiting patiently. And the worst thing that can happen on radio is what they call dead air. Well, it's kind of the same with webinars. So keep your questions short. And if it looks like, you've encountered a situation that is particularly complex or unique to your department, we'll do one of two things. We'll wait until the end of the presentation and I'll return to it and we can talk about it there for the good of the order, or we can take the conversation offline. The contact information for our office is on the screen right now, and we have people just waiting for your phone calls or emails to come through. Usually, on something like this, it's forwarded to me, and I'll try and get back to you as soon as possible and get you steered in the right direction. So, please be patient with issues like that, but we're more than happy to accommodate you. Okay, I think that takes care of all the preliminaries. Let's go ahead and dive into today's topic, right to know law for law enforcement. Okay. Why is the right to know law important? Let's get, a couple foundational issues on the table right now. I think it's important that we keep in mind that the purpose of the right to know law is to give the public access to public records. All right, if you're familiar with the law, seems like a fairly basic statement, but you would be amazed at how many people on both sides of the equation, departments and the public, misunderstand what the right to know law is all about. I think they see that term right to know and just assume that it's like Google for government. And they can ask for reports, they can ask for research, they can ask general questions. And that's really not what this law is all about, okay? You file a right to know request because, number one, you need a public record, or you need a record and you're presuming that it's public. And that has, quite a few dynamics in it. First is that, you need a record. That's the foundational purpose of the right to know law. And second is that it's a public record. Now, there are a number of people who will file right to know requests for records, maybe about themselves, about their case, about their, case, I think is probably the best word for it. And while they may be entitled to it or they may have a need for that record, It's not necessarily a public record, okay? Sometimes I have to remind people of that, that, yeah, maybe you are entitled to this, but is the right to know process really the appropriate means for getting this record? Because when you file a right to know request, essentially what you're saying is that this is a public record that everyone can see. All right. And suddenly, you kind of get the sense, the light bulb comes on. It's like, well, I don't want anyone else knowing this. So the right to know process may not be the appropriate venue for acquiring the record that they're looking for. And we'll talk about incident reports, investigatory records, and the like. Again, maybe there is a legal reason for acquiring the record, just not necessarily through the right to know process. Also, like I said, the right to know law is not intended as like Google, file a question and expect the officers or the administrative staff to run around and come up with an answer, because that is not necessarily seeking a record. Also, earlier I mentioned research, and this is just on my mind because we've had a couple requests like this at the office this week, where it's almost as if you get students who want you to write their thesis for them, okay? And we'll do all the research. And that's not the way it works, okay? If you're looking for a record, the agency is obligated to respond. But if you're looking for, data that's sliced and diced in any particular way, that's not the purpose of the right to know law. That's work that you have to do. That's work that the requester has to do on their own. Okay, so in addition to this foundational statement, we want to keep some things in mind. Under the right to know law, every record of an agency is presumed to be public. Okay, that's your starting point. You receive a right to know request, and the presumption is that all of our records are public, unless the agency can make a legal and factual case otherwise, that the record should not be released into the public domain. The burden of proof is on the department to show that the records being requested are in fact not public. And it's a lot more than simply saying, I don't think you should have these. Rather, you need to make your legal case for doing so. Now, there are a lot of people, when they first encounter their first right to know request, or they find out about this law, they get wigged out and think, oh my gosh, everything in the office is going to be on the front page of the paper tomorrow, or on somebody's Facebook page or whatever. And I can tell you with confidence that that is not the case. That if you were to receive a right to know request for a record, and let's just say, something doesn't feel right, it just doesn't seem like this should be public, there is a very good chance that there will either be what's called an exemption within the right to know law that makes that record confidential, or allows you, I shouldn't say makes it confidential, but it allows you to withhold it because of its sensitive nature, or there might very well be another law that deems that record as confidential. And as we go through the presentation here, that's what I'm going to focus on. What is it that law enforcement needs to be aware of to both properly process right to know requests and identify what tools are available to withhold those records where it just doesn't feel right, like these should not be released. And then ultimately, if there are no exemptions, or if there are no other laws, then chances are you are identifying a public record that should be released in response to the right to know request. So while there's a lot to the right to know law, for law enforcement, what we're going to do here this morning is kind of narrow our focus on just those issues that most law enforcement officers, most administrative staff, non-uniform staff for law enforcement agencies need to be aware of, okay, to kind of just get you through what we're going to talk about here this morning. All right, so these foundational statements aside, let's jump into what you need to know specifically. we're going to assume that your department is subject to the right to know law, and it would be difficult to find a law enforcement agency in Pennsylvania that is not. So there are some things that you have to do. The most important is appoint an agency open records officer, or what we call an AORO. These are the people legally responsible for receiving requests, processing requests, and ultimately responding to right to know requests. And if I use the term right to know and open records, the two terms are interchangeable, no real difference. So if you have a website, this information needs to be posted, but it also needs to be posted physically within your buildings. You have to have the contact information for the AORO. You have to have a form available for the requester so that they can file an open records request. With your posting, you have to have the applicable appeals information. This is important because for law enforcement, it can be different than everyone else. Then you need to instruct all your staff that if they receive a right to know request, they need to get it to the AORO as soon as possible. And that's important. It can't sit somewhere waiting for an inconvenient time to get it to the AORO. Rather, it needs to happen as soon as possible because of the hard deadlines that are built into this law. And then finally, you need to notify us, the Office of Open Records, who your AORO is. On our website, we maintain a database of AOROs statewide. Most of it is populated automatically through Community and Economics Mundstat system, but there's also several entries where we rely on voluntary compliance, and we recognize, people retire, they move on, they get promoted. So in order to keep this database up to date, and we use it for the public, the public can access it to find out who your AORO is. You can access it to find out who other AOROs are. And we use it to reach out in case there's an appeal filed with your agency. So it's important that it be kept up to date. So check it out every so often. If it is out of date, there's a form there that you can complete with all the current information for your department. You email it to us on an email address that's provided. We verify it, and then we update the database. Now, as far as AOROs go, they don't have to be sworn in. They don't have to be voted on by a board. We view it as a work assignment. Depending on your department, you can have more than one AORO. And depending on your municipality, you can have more than one AORO. You can have one person functioning for the administrative side of the municipality, and then a second AORO limited or specific just to the law enforcement agency, your department. Okay, you can do that, no problem. Just so it's clear to the public. Okay, look at it from their perspective. I need a record. I have a right to know request. Who do I give it to, and how do I get it to them? Okay, if you make this as easy as possible from the public's perspective, your job gets easier as well. So we really recommend that you take a look at your processes, sure everything is crystal clear as to how the public deals with this issue and works their way through your department. So there are some things that you cannot do under the right to know law. The first is that you cannot limit the number of requests or the number of records that a person asks for in any specific time frame. You can't say something like, ma'am, I'm sorry, you already filed 3 requests this week. That's all we allow. Now, let me go off script a little bit here. For the most part, people use the right to know law to legitimately request records that they're seeking. But every so often, we hear of someone who has weaponized the right to know law. Somewhere along the line, the relationship broke down between that resident and the department. They've decided they're going to be a pain in the neck. And one of the ways they do this is to file a lot of frivolous right to know requests. My take on this is that the solution is on the payment side of the right to know law. And we'll talk about that briefly, but if you really want to know how to deal with these folks, we have another webinar. It's called Payment Issues, and I would suggest that you sit in on that to get a good understanding as to how you can use the payment side of the right to know law to deal with what we call frivolous requesters, frequent flyers, problem requesters, and the like. Okay, so that will help you out greatly. The other thing that you cannot do is compel a person to tell you why they are filing the right to know request. Okay, they can file it for any reason they see fit. You cannot deny a right to know request based on the reason or what you think the reason is. Okay, that's in the right to know law, section 1308 makes it quite clear. So I like to describe the right to know process as an obstacle course. And this obstacle course has 2 hurdles. And in front of the second hurdle, there are 3 hoops that you have to go through before you make it over the second hurdle. Once you make it over the second hurdle, then you have a public record. But let's take a look at everything we need to get through before we're saying it's a public record and it can be released in response to a request. And just real short here, the first hurdle, we need to answer the question, is the request seeking records? Then we come up to the second hurdle and the 3 hoops. First hoop, are there any exemptions? Second hoop, are there any other laws? Third hoop, does privilege apply? Okay, so that's what we're going to talk about for the next several minutes. And this first hurdle, well, I'm sorry, I'm getting ahead of myself. First, we receive the request. All right, so what do? Well, we have a number of deadlines that need to be met, or that we're up against. So when you receive a request, you have 5 of your business days in which to provide an initial response. Now, business days, law enforcement, for the most part, is a 24/7 operation, but a business day would be interpreted as those days when the public has access to come in and conduct business. So primarily it's a Monday through Friday operation, depending on the size of your department. If your administrative staff and the offices are closed for a holiday, that's not considered a business day. If there's a weather emergency, that's not a business day. Obviously, Saturdays and Sundays would not be considered a business day. Those days when your offices are open for administrative operations and the public has access would be considered a business day. Now, let's say that for whatever reason, you can't get the response out, the initial response out within 5 business days. The law allows you then to unilaterally invoke a 30 calendar day extension. But in order for that extension to be valid, there are some conditions that need to be met. First, you need to invoke the extension within the 5 business day window, meaning you can't wait until like the 6th business day, suddenly realize, oh my gosh, I forgot about this right to know request. Well, we'll just take an extension real quick. Unfortunately, because you missed the first deadline, you've denied the request by default. It's what's called a deemed. So keep an eye on the calendar and get your extension notice out before the end of the 5th business day. It needs to be in writing, and if you receive the right to know request like by email, it's okay to send an email back because that's a written response. Then you need to provide a reason as to why you're taking the extension. And if you go to section 902 of the law, there's actually a list of 6 reasons that you can pick and choose from, any that apply. It could be we keep these records off-site and it's going to take us longer than 5 days to go out and sort through them. Or we want our solicitor to review our response to make sure we're not giving out anything we're not supposed to. All kinds of stuff like that. It pretty much covers all the reasons that you would typically encounter. Don't get into the habit of just automatically taking the 30-day extension, whether you need it or not. If you can get the response out in 5 business days, please do so. Because there are some records, like budgets and so forth, that are just automatically presumed to be public and readily available. So try and get them out within that 5-day threshold. Okay, so you've got the 5 business days, and then the 30 calendar days get tacked on to the end. The clock starts ticking on the extension on what 6th business day. All right, although there is no 6th business day, but I think you know what I mean. And you just count 30 days, and that would include Saturdays and Sundays. It would include holidays, and it also includes weather emergencies. Now, the next deadline that you need to be aware of is if you, in fact, deny the request, the requester has 15 business days in which to file an appeal. All right, but that's more or less on them as opposed to you. But nevertheless, it's important that you be aware of it. Okay, so now we're at that first hurdle. And the question that needs to be answered is that, is the person requesting a record? Notice I didn't say public record, but just a record. And in order to know what a record is, what the difference is, we actually go to the right to know law itself in the definition section. And there we find the definition of a record. Any information, regardless of its physical form or character, that documents a transaction or activity of an agency. See how we have that phrase highlighted. And that's what's critical. Documents a transaction or activity of an agency. Well, what does that mean? It means that in order to be a record, it needs to be about the department and its operations, okay? So why would this be important? Because all day long, we generate communications that aren't really about the department. Some quick examples. I understand a new restaurant's opened up downtown. Do you want to meet for lunch tomorrow? Or, what do you think of the trades that the Eagles have been making and how it affects next season? Or I'm picking up a gallon of milk on the way home tonight. Okay, all common communications, but yet have nothing to do with documenting a transaction or activity of the agency. Thus, they don't meet the definition of a record. And because of that, they're not considered responsive to the right to know request. So if someone were to submit a right to know request for, let's say, my emails, those messages, those examples that I just gave, because they do not meet the definition of a record, they're off the course, okay? They're no longer considered responsive because they're not even considered records, much less public records. So I don't have to worry about communications like that being released through the right to know process. Now, an important point that I need to make here is that the law does not distinguish between the messages that I send on my work computer or my work phone as opposed to my home computer, my personal Gmail account, or my personal smartphone. It's the content of the message that determines whether or not it's a record, whether or not it's a public record, not how the message was sent or where the message is stored. So if I'm using my personal phone or my personal computer to conduct work, those messages may in fact be discoverable under the right to know law. So I'm not saying there's anything wrong with using personal accounts, personal devices. I'm just warning you that they could be subject to discovery. And discovery, I'm using that as a generic term, under the right to know law. So you just need to be aware of that in case you do receive a right to know request for messages that may have been generated on a personal device. Okay, so that's the first hurdle, and that's how we respond to that, how we consider it. Okay, the other part of this definition is any information regardless of its physical form or character. So I want to talk about this real quick. I mentioned the term public record, and yeah, a piece of paper pops into your head. Makes perfect sense. But the right to know law, as you are probably aware, also accommodates electronic messages. So yes, emails, phone records, Word documents, Excel spreadsheets, various database applications, text messages, The size of the record doesn't matter. So in some instances, yeah, it could be a blueprint. Audio recordings, most public meetings that your municipality would hold, typically they are recorded many times for purposes of generating the meeting minutes. Okay, well, those audio recordings are considered public records and or are considered records that may be public. Usually they are. So they would be responsive to a right to know request. Then we get into security camera footage. And this is an interesting one because I'm going to talk about another law here soon called Act 22. But for our purposes here, security cameras, let's say that you are in, your department is housed in the same building as the rest of the municipality, whether it be, city, borough, township. And there's a security camera out front that covers the front entrance. Now, if that security camera is monitored and the recording equipment is monitored by the administrative, the non-law enforcement staff, then the right to know law is appropriate. It covers it. If, however, the monitoring and the recording equipment end up on the law enforcement side, then the right to know law does not apply, and this other law called Act 22 has jurisdiction. Okay, so non-law enforcement, it's right to know law. Law enforcement, it's Act 22, even though it's the same camera. That's how it works because of language that's in Act 22 that covers security camera footage. And then finally, social media, like your Facebook pages, your websites, and the like. Right to know law does cover social media. And this in no way is to throw cold water on your use of social media to let the public know what it is you're doing. Just be aware that you can file a right to know request for social media postings, and more than likely they would be considered public records. What's nice about it, though, is that because social media is already in the public domain, your response is as easy as saying, that's on our website, on our Facebook page, it's the link to it, and that's all you have to do. Okay, but just be aware, social media postings are usually considered public records. Okay, so I promised to talk about Act 22. It's actually Act 22 of 2017. And this specifically covers dash cam and body camera footage, but also security cameras that fall under the purview of law enforcement. This footage is not covered by the right to know law. It used to be, but in 2017, that all changed. It's now covered by Act 22. You're not going to find a lot of guidance out there. However, if you go to our website, we do have a page specific to Act 22. We even have a form. Now, this is not an official form, but it's a form that we just came up with that people could file with law enforcement agencies when they're seeking video footage. But all the rules are different related to Act 22 than from a right to know law request. And our office is not involved in any way with the Act 22 approval process. The person would file, the requester would file within 60 days of the footage being generated, a request with the appropriate law enforcement agency. And the law enforcement agency then has 30 days to provide a response. And unlike the right to know law, the police department can charge any reasonable fee, which would include charging for labor. Under the right to know law, you can't charge for labor. Under Act 22, you can. If you end up denying the person's request for the dash cam or the body cam footage, they appeal directly to court. And for most local law enforcement agencies, that would be your county court of common pleas. So rather than coming to the Office of Open Records, they have to go directly to the County Court of Common Pleas, And there they have to file all the appropriate filing fees that the county normally charges. So most Act 22 activity is done by media outlets and not the public per se, but I am aware of, some limited cases where people have filed and successfully obtained video footage using Act 22. But for the most part, you need to be aware of the difference. Body cam, dash cam footage is Act 22. For the most part, everything else is right to know law. Okay, so that's how all that works. There is a good resource available with the Pennsylvania State Police. They are more or less the lead agency when it comes to Act 22. So any questions that your department may have, I would suggest working through them. And more than likely, they'll cooperate and provide you with the guidance that you need. Pardon me. Okay, so now we're up to the second hurdle and those hoops that are out there in front of the hurdle. And we need to answer the question, is it a public record? Okay, notice the distinction. First hurdle was, is it a record? Now we're up to the point where, is it a public record? So there's some things we need to take a look at. First is, are there any exemptions that apply? In this, I'm specifically talking about the right to know law. And if so, are we going to invoke them? Now, in a little bit here, I'm going to talk about the specific exemptions that you need to be aware of. But for now, let me just explain what an exemption is. You go to Section 708B of the Right to Know law, and the law is on our website. You can download it. It's not necessarily a hard law. It's not a long law per se, and it's not a difficult law to read. For the most part, it's written in common English. There are some parts that you kind of gotta, read between the lines and maybe have a solicitor help explain it to you. But for the most part, you can understand it, especially 708B, where the exemptions are. There are 30 exemptions, and an exemption, for the most part, is a definition of types of records that the department can withhold from public disclosure if the record falls within that definition. These exemptions cover an incredibly broad spectrum of records. And for the most part, they all make common sense. You look at them and you think, well, yeah, there's no way we would release a record like that. For instance, there's one that says, if you release a record that could result in someone being physically harmed, you can withhold it. All right. Now, it can't be hypothetical. I mean, you have to make a serious case. For instance, if someone was able to obtain a protection from abuse order, all right, that is a court saying that there is a true and credible threat to this person's safety. So if you had a record that would somehow release information that is related to that PFA that could result in physical harm to the subject of the PFA, then yeah, you would withhold it, okay? And that is one of the exemptions. There's another one that specifically deals with law enforcement. You would not release the home address of a law enforcement agency or the name of an officer working undercover. Okay, that's 708B6, if I recall. All right, so another one for health-related records for any employees. Or there's another one, anything that would release the home address or personal information of a minor. Okay, it's all off the table. These exemptions are out there. And they basically say, and I'll talk about this too, that the agency, the department, has the discretion to release it. But if an exemption applies, then you have the discretion to withhold it. Okay, the law doesn't say you must withhold it. It says you can withhold it. So that's what the exemptions are all about. A very powerful tool that's available to all agencies to use, provided the record falls within the definitions of one of these exemptions. Okay, so that's the first hoop. Then we come up on the second hoop. If you don't make it through the first hoop, you're off the course, okay? You haven't made it. But the second hoop, and this is a very important one, especially for law enforcement, are there any federal or state statutes or a judge's order that make these records non-public, okay? And if so, they trump any discretion that you may have in the right to know law. Remember with the exemptions, and I said you have the discretion to invoke them or not. Usually, with another law, there is no discretion. If it says the record is confidential, you must withhold it. And if that language is in there, then that trumps any discretion that the right to know law would otherwise give you, okay? You must withhold the record. Now, for law enforcement, there's a big one out there, and it's called CRIA, the Criminal History Records Information Act. And CRIA is a state statute that basically says there is a universe of records that can only be shared with other certified law enforcement agencies as defined by CRIA. Okay, and I emphasize that point because there are other laws that define law enforcement agencies that are much broader than CRIA. For instance, I mentioned Act 22. Do you know that under Act 22, a school district could be considered a law enforcement agency? Under CRIA, there's no way. CRIA, you must be certified as an Act, 120 law enforcement agency, and you can only share records with other law enforcement agencies. Okay, and if you fail to do so, if you somehow share an identified record outside of that, there could be both criminal and civil sanctions against the department for erroneously sharing records outside of a certified law enforcement agency. This is important because the breadth of records that apply to law enforcement under CRIA is much broader than what is available under the exemptions in the right to know law. For instance, intelligence information. CRIA says that you will not share intelligence information, criminal intelligence information, outside of the law enforcement world. The right to know law makes no mention of intelligence information. And if you happen to keep a file on suspected gang activity in your municipality, I could get that under the right to know law. But if you invoke the appropriate provisions of CRIA, then I thankfully cannot get that information. So in order to meet your burden, remember at the beginning, the burden falls on the department to show that the record is not public. You would cite the appropriate provisions in CRIA or any of these other statutes or a judge's order that make the record non-public. That's how you would meet your burden. Okay, and if you're doing so, then again, the request is off the course, okay? You don't make it through the second hoop, and you're saying that this is not a public record and the request is denied. Then we come up on the third hoop. Is the record protected by privilege? And here we're talking about attorney-client privilege. Most municipalities, most departments rely on the advice of a solicitor for legal guidance, legal direction, legal advice. Those communications are covered by attorney-client privilege. In Pennsylvania, that's part of the rules of evidence, and it's protected by statute. And in the right to know law itself, you would refer to Section 305. If a record is subject to attorney-client privilege, then it's off the course, okay? It doesn't make it through that third hoop because of the confidential nature of that communication back and forth between senior management and the solicitor. All right, I promised to talk about exemptions that are specific to law enforcement. Of the 30 exemptions, there are 3 that you really need to be aware of. The most important is 708B16. And this is where we're saying that a record is critical to a criminal investigation. And the investigation does not have to be active, okay? There's no statute of limitations on this. It could be a 25-year-old cold case, sign, a conviction, jail time, whatever, okay? But if the record is critical to that criminal investigation, then the right to know law allows you the discretion to withhold it from release. Now, this does not include what's known as blotter information or incident logs, okay? And that would be the typical information that's memorialized by a department on shift activity. At 3:30 p.m., officer so-and-so was dispatched to investigate a noise complaint at this particular address. Okay, that would be considered blotter information. You're not including any of the information on the incident report that may have been or that may be of an investigatory nature. Another point that we need to emphasize with this particular exemption is that there is a court case where the Commonwealth Court of Pennsylvania said that police incident reports, by their very nature, are investigatory, and thus the B-16 exemption applies. So connecting the dots here, you can withhold incident reports from disclosure under the right to know law by invoking the B-16 exemption, because that court case includes language that says incident report is investigatory, B-16 applies, thus it's not a public record. Now, many departments will actually have two versions of an incident report. And it's because, one, they want to be able to give out in response to inquiries from the media. And the second includes the investigatory material. So they give out the first and not the second. But that's up to you as to how you want to run your department. I understand that there's even some software available for law enforcement agencies that allows you to do that. Don't know the name of it, but I know that there are some departments that utilize that. Okay, then the next exemption is 708B-17, and this is for non-criminal investigatory records. So there are times, depending on the size of your municipality and just the types of calls that you deal with, where officers are dispatched to investigate situations where there's clearly no criminal element to the investigation. Sometimes it's like code enforcement. Okay, your municipality has a police department, some sort of law enforcement presence, but it doesn't have a code officer. So someone calls in complaining about their neighbor's yard, and it gets assigned to the police department. So the officer's got to go out and look, is this yard, in violation of some code? All right, well, that is a non-criminal investigation. And the law allows, for instance, withholding the person who called in the complaint and any notes that the officer may have taken while responding to this call. Okay, that's all off the table because this exemption applies. Another example might be the department getting dispatched to an apparent suicide. And, depending on what's found at the scene, it's obvious that the person took their own life. There's a suicide note, and, there's no criminal evidence whatsoever. All right, so it's, clearly not a criminal investigation. So there, the B-17 exemption could be invoked in order to withhold any of the investigatory records, like, possible photographs, suicide notes, any evidence that may have been collected at the scene. All right, and then the third one is specific to emergency dispatch, your 911 center, or if your department has local dispatch, that would be included under this as well. 708B-18 covers any recordings of phone calls or radio communications with the emergency dispatch center. And it's written very tightly. They can be withheld for any reason whatsoever. Okay, the public, even if it involves, a victim or the caller. They cannot get copies of those recordings. Now you're thinking, well, I've heard them, on the radio or on TV. And that's because at the discretion of the emergency management director or possibly the courts, okay, they will allow releasing these recordings if it's deemed in the public interest to do so. Maybe it would help solve a crime, prevent a crime, or it's just in the public interest that they release these recordings to the media. Okay, so that's how that all works there. But for the most part, these recordings are considered confidential under the right to know law. There's also another law that, if you're with a 911 center, it's called Act 30, I think of 2016, that covers any information coming out of a 911 center that relates to victims, callers, witnesses, and the like, as well as specific addresses that are withheld. Okay, and you want to get familiar with that because that very tightly covers that information and determines what information on a much broader sense can be released. Okay, so let's say that you've invoked one of these exemptions and you've denied the request. For law enforcement, the appeal is different than most other right to know denials. And that is because if you deny the request by invoking 708B16, where remember, you're saying that this record is critical, I'll get this right before the end, is critical to a criminal investigation, then the appeal does not come to the Office of Open Records. Rather, it goes to your county district attorney. And the DA will have either a deputy or an assistant assigned as the right to know appeals officer. And they will review the appeal to determine whether or not your denial was in fact appropriate. And you can find all of the denials, or I'm sorry, all of the determinations from the district attorneys on our website. They file them with our office. And you can, research your own county to see how they've ruled on various appeals. But all other appeals, if they don't involve the B16 exemption, come to the Office of Open Records. So you would detail the way the law works is that the individual has 15 business days from the date of your denial or when your denial was due to file an appeal with the appropriate county district attorney's office. Okay, earlier I mentioned costs. The right to know law is not free. That's one of those other areas that's commonly misunderstood. And I mentioned our payment issues webinar. But real quick here, if you're making hard copies that you're releasing in response to a right to know request, you can charge up to 25 cents a page for 8.5 by 11 or 8.5 by 14, single-sided black and white. If you're providing electronic records, you cannot charge. Okay, there's no charge for electronic records. Everything else would be postage or actual costs. Doesn't necessarily apply to law enforcement agencies, but something you need to be aware of. If you're mailing something out, you can add postage onto the cost of what you're doing. There is no cost for labor. Okay, if it takes 2 hours to assemble a response for a right to know request, you can't charge the requester the 2 hours that employee spent on that, okay? It's just considered the cost of doing business under the right to know law. All other legislated charges take precedent, meaning that if there is another law that says you can assess a charge above and beyond the right to know law, then those charges, those fees, take precedent over the right to know law. 2 quick examples or 2 quick points to make here. Under the Pennsylvania Motor Vehicle Code, a department can charge $15 for an accident report. So someone submits a right to know request for an accident report. You don't charge the 25 cents a page per the fee schedule of the right to know law. Rather, you charge the $15 as dictated by the Motor Vehicle Code. Another point that I need to remember when I said incident reports are not public records. So if you receive a right to know request for an incident report and you decide to release it because it's not a public record, the fee schedule for the right to know law does not apply. And you can charge any reasonable fee for that incident report that you've chosen to release because it is not a public record. Fee schedule, public record. See the logic here. Now, one, you can withhold incident report, but if you exercise your discretion to release it, then you can charge, and that would include the cost of labor if you deem that appropriate. Okay, so we are at the end of our presentation. I have not seen any questions pop up here, but if you do have questions, now's the time to get them in. While I'm closing up here, I do want to encourage you to take a look at our website. Okay, it is the best government website you will ever see. It's updated 6 days a week with new information, decisions that our office has issued, court decisions, training opportunities. The fact that, this webinar is being held here today was tweeted earlier this week through our Twitter account. We have a law enforcement guide. Okay, Judy, yes, the PowerPoint that I'm using here today, along with all the PowerPoints that we use for our webinars, can be found on our website. Go to the training page, the main training page, scroll down, and you'll find the PowerPoints that we use for all our webinars that you can download. Ray, how about a request for 302 paperwork on a spouse? Chances are that no, you will not get that. Number one, it's investigatory as far as law enforcement is concerned. Number two, 302 falls within a couple exemptions within the right to know law. It's considered a medical record, and the right to know law covers medical records. They would not be considered public. And think about this. Someone may have a legitimate need for the 302 paperwork, but if you're using the right to know law, you're saying it's public, meaning everyone has a right to it. 302, obviously, you would not want to be public. So you've got the medical record exemption, and then there's also another one regarding anyone receiving social services. And you can make the argument that a 302 commitment is involving social services. So, the short answer is no, and then the long answer is, what I explained. And I'm guessing you will probably find provisions in other laws regarding the provision of medical services and 302 services that would deem those records as confidential and would remove any discretion that the department would have to release those. Rebecca, when another payment issues and right to know law training will be offered. Yeah, we're going to have some hiatus here come April. Fact of the matter is I'm leaving the Office of Open Records at the end of March. There's going to be a break during the month of April on any webinars. I'll be coming back on a very limited basis in May, and we'll resume webinars then. If you need a recording of a previous webinar, we have those available. Send us a flash drive, like I said at the beginning, and we'll be able to make you a recording of one of these sessions. Payment issues, I think we'll be getting in probably a right to know session before the end of March. Payment issues is another story. I'm not sure when another one will be rescheduled. Okay, but we'll do our best to do that for you. All right. Hopefully I've answered your questions. Back to the website, we do have a law enforcement guide that covers a lot of what I've talked about here today. You can download that for free from our website. It's a good resource. If you are a real geek about government transparency, you can subscribe to our Twitter feed, and every morning we will wake you up with a tweet with all the news that's fit to print for that day in the world of government transparency. Vicki, send the flash drive to our office, 333 Market Street, Office of Open Records. The address is part of this presentation, and you can find it on our website, no problem at all. And remember to include a self-addressed stamped return envelope so we can get the flash drive back to you. All right, so I think we're pretty much at the end here, right? Maybe, a little ahead of schedule, but we didn't have many questions today. So I want to thank you for your participation here this morning. I hope we provided some good guidance. And if you have any further questions, feel free to reach out to our office. Phone numbers on the screen, as well as the address up for our website, where there are email accounts. We like to turn around as quickly as possible to get you the information that you need. But otherwise, again, thank you for your participation here this morning, and hopefully we'll see you soon. Stay safe out there, folks.